On March 29th of 1961, the state of Ohio joined 37 other states by voting to ratify the 23rd Amendment to the United States Constitution, which reads in full, "The district constituting the seat of government of the United States shall appoint in such manner as the Congress may direct a number of electors of President and Vice President equal to the whole number of senators and representatives in Congress to which the district would be entitled if it were a state, but in no event more than the least populous state. They shall be in addition to those appointed by the states, but they shall be considered for the purposes of the election of President and Vice President to be electors appointed by a state, and they shall meet in the district and perform such duties as provided by the 12th Article of Amendment. The Congress shall have power to enforce this article by appropriate legislation." Proposed by Tennessee Representative Estes Kefauver, the measure was ultimately ratified by 40 states in total, while Arkansas rejected the amendment and the 9 remaining states took no action. An attempt to repeal the amendment was made in August of 1978 when California Representative Don Edwards proposed the District of Columbia Voting Rights Amendment, which was ratified by only 16 states, the most recent being Delaware in June of 1984, but which laid the groundwork for the District of Columbia statehood movement. In November of 2016, 85.7% of district residents voted to petition Congress for statehood, proposing to name the state the Washington-Douglas Commonwealth, and in January of 2019, D.C. Representative Eleanor Holmes Norton introduced the Washington, D.C. Admission Act, a bill that was approved by a vote of 232 to 180 before reaching the Senate, where Republicans refused to consider it as Donald Trump threatened to veto it. Representative Norton has continued to reintroduce the bill at the beginning of every Congress since, most recently with the support of Maryland Senator Chris Van Hollen Jr.